Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Montana and outline some simple steps that landlords can take to initiate an eviction. In this video, we'll talk about what the eviction process looks like, how Montana laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? Eviction is the legal process needed to remove a tenant from a property. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property. This is sometimes called a self-help eviction and is never permitted, even if a tenant refuses to leave after violating the terms of a lease agreement. A landlord must seek an eviction from the court. Note that this is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. If a tenant in Montana fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. Most states use different notices for different breaches, but in Montana there is just one form. This is simply called a notice to quit. The form, which can be downloaded from the eForms website, asks the landlord to check a box to indicate how the tenant violated the lease agreement. If the violation relates to refusing the landlord access to the property or changing or removing locks without the landlord's permission, then the notice to quit gives the tenant 24 hours to allow access or fix the problem. If 24 hours pass and nothing has been done to remedy the situation, then the tenant must move out within 14 days. Lease violations related to failing to pay rent, housing unauthorized persons or pets, or damaging the property are considered curable. The notice to quit for these issues gives the tenant 3 days to either fix the problem or face eviction. Incurable violations, on the other hand, are violations that cannot be remedied. If, for example, the tenant is charged with gang-related activity or the production of illegal drugs, then the landlord can serve a notice to quit, ordering the tenant to move out within 3 days. Also, if the tenant is caught committing the same curable lease violation for the second time in 6 months, then a notice to quit can give them 5 days to move out. The notice to quit can also be used to end a weekly or month-to-month tenancy. In the case of a weekly tenancy, the notice to quit instructs the tenant to move out within 7 days. In the case of a monthly tenancy, the notice will order the tenant to move out in 30 days. If the tenant does not respond to the notice to quit, the landlord can initiate the eviction process. In order to do this, the landlord will file 2 forms known as a complaint for possession and a summons in either the city court, municipal court, justice court, or district court. The complaint for possession is a form that asks for information about the landlord, tenant, and the lease violation. The summons tells the tenant when to appear for court. This form also warns the tenant that if a counterclaim isn't filed within 10 days, the landlord may ask the judge to rule in their favor by default. The landlord will also file a form known as a request to serve form, which takes the sheriff to serve the complaint and summons to the tenant. Once the sheriff has served these documents, the sheriff will file a proof of service or a form proving that the documents were delivered. After being served with copies of the complaint and the summons, the tenant has 10 days to respond. If the tenant responds by filing a form called an answer, the court will set a hearing date. Generally, this will occur within 20 days of filing the answer. If the tenant doesn't file the answer form, the landlord can ask for a judgment by default. In either case, if a judge decides to return possession of the property to the landlord and the tenant still refuses to move out, the landlord can fill out a form to obtain a writ of assistance and file it with the court. The writ, when signed by the Justice of Peace, authorizes the county sheriff to remove the tenant and the tenant's possessions from the property. We've got everything you need to get eviction proceedings going, from eviction notices to court documents, and you can access all of them at the link below.